day everyone, my name is Heng Exi with metric number 254807. So in this video, I will be presenting about my assignment 2 of Criminal Procedure 2. So now, let's start with my presentation. For your information, when an accused pleaded his guilty or to be found convicted before the court, there's actually a chance for the lighten or even the increase of the punishment for the particular offense that he committed. Hence, there will be two parties who seek for different pleas. For the accused or for the defense, they are entitled to make a plea in mitigation. And also at the same time, the prosecution is also entitled to make a contradict plea in order to increase the punishment or seek for a heavier punishment. Then, the court is empowered to make its decision to pass the sentence in favor of either side. Of course, when making such decision, the court will always consider both the mitigating and also the aggravating factors. Mitigating factors will be relied on any facts or circumstances that might lighten the punishment for the offense. Meanwhile, on the other hand, the aggravating factor that tendered by the prosecution side will be relied on the circumstance and also the fact of the case to seek for a heavier punishment. For the mitigating factors, I roughly categorize it into 6 types. First and foremost, the age of the offender. Normally, the defense will try to seek for a lighter punishment for the one who deemed to be youthful or elderly offender. Based on the interpretation of Section 2 of the Criminal Procedure Code, youthful offender refers to the one who is between the age of 18 until 21. Meanwhile, elderly or aging offender is referring to those who attain the age of 56 or above. For instance, an elderly offender is not capable to receive the whipping punishment in terms of his physical condition. Therefore, the defense may apply this ground to seek for a lighter punishment in order to substitute the whipping punishment. Secondly, when the offender pleaded his guilt, the court will consider for the mitigation of the punishment. As in the general rule, the punishment may be reduced between the range of 1/3 or quarter. This is to say that if the offender is supposed to be sentenced for 10 years of imprisonment, the punishment may be reduced to around 6 until 7 years only. However, the reduction of such punishment upon the plea of guilty is not a strict rule as well. In the case of Bachik bin Abdurrahman against public prosecutor, where the public interest demands a deterrent sentence, the plea of guilt should not automatically entitle an accused to get a lesser punishment. Next, the offender's former record and also the gap principle shall be the third mitigating factors. Lighter sentence will be considered by the court if the offender is the first-time offender or the one who has no any criminal records. Nevertheless, courts will always consider the clean records of the offender and also the seriousness of the offense that committed by him. In Ng Atak against PP, it was held that the public interest shall always be given priority over any clean records. Next, the fourth factor would be the conduct of the offender after the commission of that particular offense. In a situation where the offender is showing remorse, then it would be a high possibility to be mitigated for the punishment. The term remorse here can best be defined as distressing emotion where an individual he regrets on what he had done in the past that deemed to be shameful, hurtful, or wrong. Apart from that, the court may also look into the factors that affecting the commission of the offense. There might be some of the circumstances that led to the commission of the offense. For instance, the provocation by the victims or the other parties, intoxication or drunkenness. Consent is obtained from the victim before the commission of offense. Okay, so for instance, the unpredictable accidents that occur during a magic show is considered that the consent is obtained from the victim. Also, the mental conditions or the financial crisis that are currently faced by the offender during the time he committed that offense. Here, we come to the last factor for mitigation, that is the effects upon conviction. With this, the court may consider the effects that cause upon the conviction. I can give an example that the offender is the only source of income to his family, and without him, there's no any financial support of the family. On the other hand, there are few aggravating factors for the prosecution in order to increase the punishment as well. Let's look into this. Firstly, the prevalence or rampancy of the offense that committed. The court will take it seriously because its rampancy will impose a heavier punishment so that it will be a lesson to the public not to do the same offense in the future. Usually, this would involve some serious crimes such as rape, robbery, kidnapping, and also some drug offense like drug trafficking. It is happening a lot, thus the prosecution will ask or request the judge to give some serious offense in order to make the accused to stop from doing the same in future. In the case of Lee Chou Ming against BP, the court considered the rampancy of armed robbery, hence a heavy punishment was served to the convictions. So the punishment are imprisonments, whippings, and fine are sentenced against the accused. During the appeal, the High Court held the same because of the seriousness of the offense that committed by the accused. Meanwhile, the second aggravating factor is the previous conviction and the bad records of the offender. There could be some offenses that frequently committed and also convicted by the offender, or the offender is repeating the same offense. Since a previous conviction, the sentence will be much heavier. In PP against Jafar bin Daud, the accused was sentenced for 8 months of imprisonment for the offense of possession of 0.21 grams of heroin. Notwithstanding that, the prosecution appealed, and due to the 5 previous convictions of the accused and 2 of them are involved in a drug trafficking, thus the court enhanced it to 18 months of imprisonment. Furthermore, the status or the position of the offender will be the third aggravating factor. Because of the high social ranking or high social status, the offender should always be punished with a greater punishment, especially some public servant or authority that they should portray a good example and a good image to the public. In the case of Datuk Harun Idris against BP, the accused here was a chief minister in the state of Selangor, and he was then charged for forgery and helping for criminal breach of trust. The prosecution had used a position against him. Thus, the federal court decided to enhance the sentence because of holding a high post and should be given a good example to the public. In another case of BP against Tan Kun Suan, the accused acted as a member of parliament, and during his defense, he alleged that he had contributed a lot to MCA. However, the court held that the facts are not considered and gave 2 years of imprisonment. The court will not look into the contribution that the accused had done, but the sentencing is relied on the offense that committed by the accused. Then, the next aggravating factor would be the use of force. The court will consider the violence that caused to the victim or the public. For instance, if a very bad treatment is caused to the victim and also the public, then a heavier punishment may be imposed, and vice versa. In PP against Muhammad Sofyan bin Abdullah and another, the accused had wounded the victim and also took a rope and strangled the victim. The court had sentenced a maximum punishment for the offense that committed. The last aggravating factor is the mode in committing the offense. In this factor, brutality is the main consideration of the court. Other than that, providing or giving any false statement will also lead to a heavier punishment. In the case of Jajinder Singh against BP, the accused was charged under Section 211 of the Malaysian Penal Code, which is making a false charge to the victim. The accused was given false evidence and statement during the investigation phase. Hence, he was then sentenced with the maximum punishment of 2 years of imprisonment. To sum up, both the prosecution and the defense may raise their respective grounds in order to lighten or to increase the punishment. However, it is still up to the discretion by the courts to decide the final sentence and also the final punishment for the accused. Thank you for watching this video.